It's no longer news that armed forces of the USA had invaded Venezuela, kidnapped its president and his wife, and flown them to USA, and have indicted them in a court in New York on charges of breaking US law. What are the international law implications of this? How legal are these under international law? And what are the implications of these developments to the global, on the global south and Africa in particular? This will be our discussion in this first episode. Now, international law since 1945 has been based on some fundamental principles and purposes, and these are found in the UN Charter, which is binding on all countries which are members of the UN. The USA was among the founding fathers of founding nations and the first signatories of the UN Charter. And most, if not all, the provisions of that charter would not have been agreed if the USA did not agree them. The first principle, and perhaps one of the most important, is the principle of sovereign equality of states. Sovereign equality of states, which means that all nations, big and small, have sovereignty and shall be treated equally. The second is the principle of territorial integrity of nations and non-intervention by other nations in the territory of states. That the territories of states are sacrosanct and must be respected. The third is peaceful settlement of disputes. Um, and the fourth, which is aligned to this, is maintenance of friendly relations among nations, which is based on the principle of equality, equal rights, self-determination of peoples, and respect for human rights. And then we have the purposes of the UN, the reason why the UN was established, which also are linked to the principles. The first is maintenance of peace and security around the world. Second is removing threats to peace and security and restoring peace and security in the world whenever and wherever it is threatened or breached. The next one is promotion of human rights and self-determination of peoples. The fourth one is promoting sovereign equality of states, which is again one of the principles, and promoting international cooperation in solving international problems peacefully. Next comes suppression of aggression, and then promoting prosperity and high quality of life for all nations. The context of these provisions, of course, was World War I and World War II that caused unbelievable devastation and death of people. Uh, Tens of millions of people, more than 100 million people died in both wars, and incalculable destruction of property. To prevent another world war, states at that time came together to agree the charter. And those principles and purposes were the key basic foundations for the UN. To achieve these purposes and principles, there are certain rules of international law and relations which were entrenched both in the Charter by state practice, i.e., accepted universal practice of nations which are seen as binding under the law. And so these rules include, there are many more, but I'm going to limit myself to the most important ones. The first one is the prohibition of the use of force or the threat of force by one nation against another. You can find this in Article 2.4 of the Charter. The only exceptions where force can be used under international law are in self-defense of a nation or by a nation that has been attacked or threatened with attack, and they can defend themselves individually or with the help of other nations. Second exception is collective security measures undertaken by the UN Security Council in order to prevent a breach of the peace or to restore peace and security where these have been breached. In other words, if a nation were to attack another illegally, the UN Security Council should take measures, including military, to defend that nation and restore peace and security. And then we have the principle of self-determination. Nations can use, people can use force and forces to fight for independence, to fight for freedom from oppression, from occupation, and things like that. They can also use force in a against apartheid, a policy of racial discrimination and suppression. And then finally, force can be used by the UN in humanitarian intervention to protect people who are being oppressed in an egregious manner by their own governments. Contravention of these rules about force could amount to aggression, crime against humanity, or war crime, or even genocide, which are crimes punishable under international law. The second rule to achieve the principles and purposes of the UN are the rules on jurisdiction. Countries' laws and jurisdiction, be it judicial, be it legislative, be it executive, apply only within the territory of countries, apply to their nationals only, apply to the protection of their vital interests where these have been impinged upon by another country. No nation has the right to apply their laws against another country or the citizens of another country or in the territory of another country. This is a well-established, incontestable rule of international law. The third rule to achieve the principles and purposes of the UN is the rule on self-determination. All peoples have the right, under international law, under the UN Charter, to determine freely on their own their political and economic status and direction. Therefore, it is for them only to determine or decide the kind of government they want, the people that will govern them, and how they would be governed. Secondly, the resources of all nations, of all peoples, belong to the peoples of that country, of that territory, and it's only them that could decide how to exploit and use or manage these resources. No third country or foreign country is entitled to exploit or expropriate or seize the resources of other nations. The fourth rule is the rule on recognition of governments. Governments of countries do not have to be recognized or accepted by other countries or their governments for them to be legitimate. Governments are legitimate on their own right in their own countries, provided they have the capacity to rule and maintain order in that country and command the obedience of their population. How they come into power is not a concern of any other nation. And whether any other country recognizes them, it doesn't matter. It doesn't make the government legitimate or illegitimate. They may choose not to interact with them or do business with them. That's fine. But it doesn't affect the fundamental legitimacy of the government in question. Number five, rule. The rule on state and diplomatic immunity. States are immune from the jurisdiction of other states. The territories of states, be it the land territory, be it the airspace above their land, be it their territorial waters, be it the minerals under their earth, these are inviolable. The embassies of nations, their flagships, their aircrafts also are inviolable. No nation is entitled to um, to encroach upon the territory of others. Likewise, officials of every country, presidents, kings, diplomats, ministers, and so on, are immune as well from the jurisdiction or authority of other nations. And this means you cannot, under the law, arrest the leaders of other countries, their ministers or diplomats, and then purport to try them in your own courts. That is not acceptable or legal. Even if what they do is wrong, as long as they do it pursuant to their office, it is called functional immunity. It stays with them for life. If they do something criminal or unlawful in their personal capacity, then they have personal immunity while in office. When they leave office, it is possible if they come to your country to arrest them and do whatever, but while in office, you cannot arrest or try in your territory leaders of other countries. The only exception to this is where a leader has committed international crimes, like war crimes, crimes against humanity, genocide, or aggression, and in which case they could be brought before an international national court like the ICC or international tribunal set up for that purpose. No country's courts has a right to arrest or to kidnap leaders of other countries and subject them to trials in their own states or countries. Number six rule of international law, which applies here, is territorial, the rules on territorial and international waters. The territory of every country that has a coastline that extends into the ocean up to about 12 nautical miles, I think. And that is part of their territory. The rest of the ocean beyond this area called territorial waters is called international waters. The international waters is free for everybody to use, for every ship to sail. It is free for all peaceful navigation. No country has the right to seize vessels belonging to other countries in the country's territorial waters or in international waters. That is a cardinal rule of international law, and the breach of that rule would amount to a violation of the territory of the country concerned. And the seizure or use or diversion of the assets in the waters would amount to international piracy, which itself is a crime. Number seven, law of treaties. All countries who sign treaties and ratify them are bound by the treaties and are required to observe the treaties in good faith and not do anything that will undermine those treaties. The principal treaty of international law is the UN Charter of 1945. US is a founding member of the treaty, a founding signatory of the treaty, and a permanent member of the US Security Council. In fact, the headquarters of the UN is in USA, New York. And that means of all nations, USA should be the most concerned about the protection, about the observance of the treaty of the UN. That is to say, the UN Charter. Right. So these are some of the key rules by which the principles and purposes of the UN are to be achieved. Let's look at now the action of the US government in Venezuela. Is it plausibly justifiable? Now, of course, it is clear that Donald Trump and his government do not pretend they've done something legal under international law. They claim it is legal and constitutional under US law. But that's a fallacy. US law has no application in this matter. What matters here is the application of international law. Trump's actions in Venezuela and against Maduro and his wife, and against those people involved in the action, those that were killed, about 80 to 100 people were killed in that operation. These are gross violations of international law. The seizure of oil vessels, the bombing of boats in Venezuelan waters, and the capture of vessels carrying oil from Venezuela or to Venezuela. These are blatantly illegal because Venezuela did not threaten USA with force and did not attack it. And therefore, there's no defense or self-defense applicable here. And the UN itself is not involved in these things. The matter was never brought before the UN or before the Security Council, and therefore there's no question of the Council or of the UN being part of it. So these are clear acts of aggression, acts of war, in blatant violation of international law. They violate all the principles and purposes I've enumerated: sovereignty of nations, equality of nations, territorial integrity, non-intervention, the ban on illegal use of force, peaceful settlement of disputes, jurisdiction, immunity, state recognition, observance of treaties in good faith, law of the seas, everything. The assault on the president of Venezuela and their residents, and the kidnap of himself and his wife, they violate the principles of state and diplomatic immunity. Maduro, or shall I say, President Maduro and his wife, are not subject to the jurisdiction of US law and US courts. They are not subject to US authorities. The laws of USA do not apply to Venezuela. US actions violate the law on self-determination. Who governs Venezuela is up to the people of Venezuela. It's not up to USA or any other country to decide. It is not for Trump to decide. It does not matter how Trump sees President Maduro, whether he sees him as legitimate or illegitimate or dictator or whatever he calls him, is of no consequence. It is for the people of Venezuela to choose their leaders and to remove them if they don't want them anymore. The resources of Venezuela, the oil, belong to Venezuelans and not to Trump or to USA. The claim that the oil now belongs to USA and that they will run the country is blatantly unacceptable and blatantly unlawful. These amount to crimes in international law, crimes under Venezuelan law, and even under US law, because kidnapping and murder in cold blood, burglary, theft of properties, wanton destruction of property, all these things, piracy, all these things are illegal under the laws of USA. All these are a big affront to international law, diplomacy, politics, and relations. It's an affront on the UN Charter. It's an affront to countries which are not as strong as USA. And it is something that must be checked before it becomes the norm. Pre-1945, those kind of things happened. And these were the reasons why the UN was established, to prevent bigger nations from trampling on smaller ones and stealing their resources or imposing leaders on them.